I've always said constitutionally that if I had to set a problem for any constitutional draftsperson, I probably said draftsman, and at the time I first said it, draftsperson, I would set Burma/Myanmar. It has more complications in legal terms, in racial terms, in religious terms, in international terms, in historical terms, than almost any other country in the world. And it's interesting to see how quickly Australia has taken up the challenge of doing something about helping Myanmar. My interest in Myanmar is, as well as historical, threefold. My primary interest is as head of ActionAid Australia, which has taken me to Myanmar on my first visit there. The country director of ActionAid Myanmar is a personal friend of mine, and I've in fact put him on the board of ActionAid Australia. And my other interest, of course, is in my role as International Commissioner of Jurists, and thirdly, that of my university. And unfortunately, I can't stay for the whole of the conference, but Professor Martin Hayden of Southern Cross will be remaining, and you can beat him up if you can't get to beat me up. ActionAid Myanmar, or ActionAid, is an organisation which doesn't deliver goods, it doesn't deliver money, it doesn't deliver things. It empowers people. And in the empowerment business, we primarily empower women. And the first inspection that I did in the dry zone was of a dam, which the government said couldn't be built because it would cost $200,000. So several villages got together, particularly the women, and we set up a women's advisory board, which was all that the women needed because they in fact built the dam. And what they did, they supplied food, they supplied labour, and for $40,000 they built a $200,000 dam, as a result of which they could go from 1 crop per year to 3. Now, in the time since July that I was there, 3 more dams had been built. And what was really interesting was that the engineer wanted a dam built in a particular place, and the women said, no, we know our river, and of course the dam was washed away. He learnt to listen to the women, and although they're technically an advisory board, they are the managing directors of it all. It's exciting to work with people such as that, and I saw a number of our projects for ActionAid there. It is an amazing country, and the resilience and charm of the people, most of you here know, is something special. My concern, however, is about the rule of law. Now, in a previous life, Chris and I went to spread the gospel of the rule of law to the Balkans. We did a rapid tour around, and I remember lecturing Romanian magistrates, who were almost all women, about the importance of what they could do as the last vestiges of law. I didn't know when we visited Podgorica, the capital of Montenegro, that I was going to the inaugural meeting of the new president then. And with Chris's inimitable style, I had no invitation at all. I just walked in behind him and went and sat down and saw the whole performance and left, he having promised that he would bring me there. He's now forgotten. It was a reminder to me, as I thought of today, just how important it was in countries that were so desperate for law books that in fact they'd take them in any language at all. They had no books at all in their libraries, in their law libraries, in their courts. They'd take any books at all. I went recently there on behalf of the International Commission of Jurists to the capital of Myanmar to talk about an interesting new phenomenon in Myanmar, which is the reintroduction of the prerogative writs. Now, all the non-lawyers here know what prerogative writs are, but the primary thing is, from 1971 to 2011, they did not have the use of the writ of habeas corpus, that wonderfully developed instrument for finding out why somebody's being held, how lawful is it, and getting them out. But also the other, so prerogative writs are judicial means whereby the right of someone to put someone away, to make a decision and so on, can be reviewed by the courts. And I had the pleasure of addressing the conference there established by the Attorney General of Myanmar, an erudite, clever, well-trained, significant lawyer who has the breadth of vision to understand what has to happen. Now, of course, most common law countries have progressed beyond the prerogative writs, and we have judicial resolution and all sorts of other vehicles. But the importance is they realise that they still have to have protections for ordinary citizens. What happened, of course, is that they all thought, well, there's been no law developed here in that 40 years. But of course, they claim correctly to be a common law country. The common law, which is not understood by civil law lawyers and not liked by it, is a phenomenal system that operates throughout the largely English-speaking world, and indeed some non-English-speaking countries. It is a continuum of learning, which means that laws that were passed shortly after World War II, 48, 49 and so on, in countries like Malaysia and countries like Myanmar, can learn from each other, so that the New South Wales Supreme Court practice has a 40-page explanation of how it all works throughout the world. So I was able to say to them, it doesn't matter that you haven't had cases here since 71. In fact, the common law has continued to develop. You are a common law country, and you can therefore rely on the laws in other countries. And one of the, and not at that conference, but shortly afterwards at another conference, someone said, well, can I have that and we'll copy it? I said, sorry, I'm a rule of law organisation and I'll organise with the owner of the book, the publisher of the book, to get a copy to you, and I'm going to do that. That conference that we addressed, and there was another judge from the Philippines and another lawyer that we addressed, started to talk to them about the writs, but the primary thing that I wanted to get across was judicial independence. And there were some judges there were prosecutors there were lawyers there were government officials there. Because, as I was able to say, aimed directly at the Attorney General, a lot of countries you can't have contracts. A lot of countries there is no enforcement unless the government wishes contracts enforced. And in China there are problems of enforceability of contracts. But I said to them, remember, China has a pocket jurisdiction called Hong Kong. And if you want to have enforceable contracts, you can have them in Hong Kong law with Hong Kong judges. And if you can build Myanmar as a common law country carrying the same tradition that Australia does, Canada, the USA, and so on, you can learn to attract business people who will make contracts under Myanmar law. That it's going to take a while to build the culture, but you need to start now so that you will attract business. Business likes enforceability of contracts. They like to enter into agreement that will be complied with. And it is in this country's interest to develop its common law traditions and in fact develop a reputation for strong judicial independence. We also talked about the independent role of the prosecutor because not all prosecutors are independent as they ought to be. A prosecutor has certain duties to the court. In New South Wales, we took away from policemen who were largely, quotes, company men, and gave it to independent Director of Public Prosecution the right to proceed with prosecutions with all the independence. So that's only part of it, but the main thing is to get across the message of judicial independence. Now, when I went to that conference, I took with me an offer from a very interesting organisation called the Judicial Commission of New South Wales, which I supported in opposition its establishment some quarter century ago. Now, most people, even in New South Wales, don't know how effective the organisation is. It trains judges and magistrates for places as far afield as Victoria. It does it for all the Australian states, the Commonwealth, Papua New Guinea, the Pacific nations, including the other judge who was there from the Philippines. He'd been trained there as well. It trains judges from Indonesia and the People's Republic of China. As well as this, so that Ernie Schmatt, the head of that organisation, is on the World Judicial Education Body. And in fact, I took an offer from him with his highly sophisticated organisation there with software that allows him to create records for other states and keep records, an offer to train the judges from Myanmar. I'm sure that AusAid would be very interested in helping that. We have, as you've heard, a very large commitment to education there, and I had the pleasure of talking with Bronte Mools about it some months ago. We Australians are committed to the spreading of education, and that's why it's such a delight to see so many Australian universities here. But it's at a tertiary level that we need the work to go on, and there's a foundation of English there, and in fact I took with me some English books just to hand around to teachers to give them that skill. So it's our opportunity to teach them the rule of law. And as well as talking to that conference, I was able to talk to the lawyers themselves in Yangon and to take them through a process of learning. Now, this was a grant from the EU to the International Commission of Jurists. That organisation, which I am Vice President in Geneva, mainly operates through its regional offices, which is the office in Bangkok. And I went with that team on this conference, and in fact, we will continue to go there to help them develop an independent judiciary and a strong profession which is necessary to underline the rule of law. Judicial independence sounds about as interesting as watching paint dry. It in fact is so fundamental that to the building of any society that I can't emphasise too much how important it is, and you don't need to be a lawyer to learn the principles, to just find out what is there. And I'll give you, for those of you that want to have a brilliant exposition of it, Jim Spiegelman, then Chief Justice of New South Wales, addressed a conference in 2001 on the judicial independence, purposes and threats. 2001, why? 300 years exactly from the Act of Settlement, which established judicial independence. Now, judicial independence is not just a creation of the English common law. Can't say British because the Scots have different law, and it's a very interesting legal system and I commend it. But the English common law is not just for common law countries. And of course, you must remember that the Commonwealth is some 53 nations, and most of whom have an English common law system. But these principles have been established in a series of international treaties, the International Covenant on Civil and Political Rights, the UN Declaration itself. The principles of the Act of Settlement have been embodied there in bar associations, in law societies, in government declarations and a series of treaties, but most significantly in the establishment of the Beijing Principles, where 32 Chief Justices, including the Chief Justice, obviously, of People's Republic of China and other regional Chief Justices, 32 re-established those principles of the independence of the judiciary. Now, what that means is the judge must decide all justiciable issues. Lovely word. What's justiciable in one country and what's in another varies. And no, there's no perfect model system for this, but there is a system that enables certainty so that people can go before an independent judge who is selected on competence and integrity, who is independent of government. And there's one government recently which will come to mind whereby the Chief Justice became head of the government. It's frowned on and it won't last. But every judge, therefore, has a series of protections. Now, for instance, in my own state, in Australia, we have a structure whereby there is a relationship between Commonwealth judges, federal court judges, state judges, district court, and so on, carefully worked out over a period of some years, working very well because they dip mainly into the pool of barristers, mainly, not entirely, but mainly, and of course there has to be a relativity between those. My own government only in the sense of New South Wales, has just decided to diminish the rate at which state Supreme Court judges' salaries go up, which of course affects my pension, but I'm so old it doesn't really matter. But it means it will soon get out of line. They ignored a Commonwealth state agreement that's been built up over some years and works very well, so that eventually people will notice the difference between a federal court appointment and a state Supreme Court appointment, and we will get out of line. Judges' conditions should not be altered. They should not be altered because that's a pressure on the judiciary. Judges' conditions are such that they must be independent. You go to a lot of trouble to make sure that people are not going to be seen with ministers, so a whole range of criteria, all of which are essential. Now that message I left with them and will reinforce with the people of Myanmar and their legal profession to say, you have something here that you need to develop, you need to grow, and in fact, that judicial independence is going to be fundamental to your future. The final thing I just wanted to mention to you is the importance of the Commonwealth. Now, the Commonwealth, of course, of nations, has within it now one nation, at least, that was not part of the British Commonwealth. It's not necessary now to be part of the former British Commonwealth. It's not necessary to be a monarchy. There are several monarchies within the Commonwealth that don't have the Queen as their head, and it's only necessary to acknowledge the Queen as the head of the Commonwealth. Although politically it's a fairly disastrous body, I mean, we're going to Sri Lanka, aren't we, for the next meeting, but the agencies work extremely well. So that I recently had an approach from from our regional office in Johannesburg, to train a court registrar in Australia. 4 emails, I had agreement from the head of the Attorney General's Department in New South Wales to train this court registrar from Zimbabwe in New South Wales. We've been doing it for years. Parliamentary Council, the Commonwealth has amazing networks for training people. Parliamentary Procedure, the Commonwealth Magistrate and Judges Association, of which I'm a member, the Commonwealth Legal Ethics, Commonwealth Law. There's a whole range, Commonwealth Parliamentary Association, of which I and many others here are members. Gives you links that enable you to learn from each other. It's a small group of 1/4 of the population of the world. It in fact can grow from the 53 nations now. There are something like 50 potential nations or parts of nations that can become part of that Commonwealth. So as long as you ignore the politics, in fact I have said to Bronte Mools and to others there's no downside to joining the Commonwealth, and in fact there are tremendous advantages. So you might just explore how easy it is to become part of the Commonwealth, the advantages of being able to train parliamentary clerks, senior office bearers, senior government officials, lawyers and whatever. There is an opportunity if Myanmar, like Palestine for instance, or many other countries, can join I've even offered it to the United States on one occasion. Well, they're entitled. I mean, they can't get it all wrong all the time. But for Myanmar, a growing, developing, very rapidly, as you know, country, I mean, don't plan to go there next week or the week after or the week after that if you want to get a visa. But they said they'd fix that. Ladies and gentlemen, I commend all of you, and I commend Chris for getting all of you together. I commend you all for helping to build this new nation. It is very exciting for me to be able to, in a small part there, to see what Australia can do with the support of our government, with the support of AusAid, and with the support of all of you people to help this near neighbour of ours become even closer to us for the benefit of both countries. Thank you.